Good evening to all of you. Welcome to Legal Matters by Sai Baba Sunkara. Right. Honorable Supreme Court of India, two judges bench, Justice A.M. Khanwilkar and C.T. Ravikumar, while disposing the case of Hukumchand Garg and another versus State of UP and another in SLP number 762 by 2020 on 7th of February 2022 held that the persons whose names are not there in the FIR, they cannot file petition under section 482 CRPC, that is for the quash proceedings. So because you should have some locus standi. Who are you to file the petition? Either your name should figure in the FIR or at least in the suspected names should be there. Without anything, how can you file a quash petition in the name of the other accuser also? This is the question raised by the Supreme Court. Looks so easy and funny, but there are some legal intricacies in this issue also. Straight away to say, ఎవరినైతే ముద్దాయిలుగా చేయలేదో వారు క్వాష్ పిటిషన్ వేయడానికి లేదు. మరి ముద్దాయి కాకపోతే ఊరిని వేసి ఉంటాడా? ఇది now we will look into the matter. So this relates to crime number 540 by 2019 of Hazratganj PS of Lucknow city. Right? Actually, the investigation was taken up by the local police as usual. It was not satisfactory to the complainant and others. Ultimately, the matter was entrusted to the CBI. CBI, they are investigating the case. They have named some persons as the accused. But this Malik Garg, Hukumchand Garg, he is not figuring as accused, but he filed a quash petition under section 482 CRPC. You may be knowing, normally, when there is error apparently on the face of record, or when there is no material against the accused in the FIR, or when the FIR has been falsifiedly made against the petitioner, then he can go for complete justice to be given by the High Court under section 482 CRPC. Please remember, section 482 CRPC gives enormous powers to the High Court to do complete justice when the lower court has exceeded its jurisdiction, or when the lower court did not exercise its jurisdiction. Everything can be corrected by means of section 482 CRPC. There are inherent powers given to the court, High Court particularly. Right. Now, in this case, this man, so the Supreme Court clearly said that you are not a party. That means your name is not in the FIR. Then how can you file this quash petition? So here the intricacy litigation is there. Please remember, when the local police, that is Uttar Pradesh police, they have been investigating the case. So they involved him as an accused. They gave a lookout notice for him. But as the time passes, nobody observed the same. Actually, literally, CBI people also have forgotten. Of course, they did not find enough material against him, so they kept quiet. So since his name was previously found in the lookout notice by the UP police, he has filed this petition for quashment. So this is the litigation. So anyway, Supreme Court did not agree for the same and clearly stated that if at all you get any doubt that you are involved in this case, you can go for 439 anticipatory bail. Why? How can you come for 482? It is not at all acceptable because you do not have any locus standi. Locus standi means the person should have some jurisdiction, should have some local standing. Otherwise, how can he file the case? So please remember, CBI did not name him. So better to keep quiet. Why should you unnecessarily poke your nose into such matters and get the wrath of the court? So however, since the matter has come and the other advocate, so advocate on behalf of the petitioner, Mr. Guntur Pramod Kumar, when he stated that previously the local police have done like this. So therefore, now the Supreme Court has given leverage to him and directed the CBI to give 48 hours advance notice to him. If at all they want to proceed against him as per law. That means if they wanted to figure out him as an accused, he has to be given 48 hours advance notice. So, and actually later only the action should be taken. So maybe a simple case, a case where within below 7 years, normally you may be knowing that only section 41A notice should be given. Like that it should have been there. But anyway, since the details are not available, as far as this case is concerned, please know the legal point. So what is the legal point here we have to learn? The person who is named in the FIR should only go for the so-called quashment proceeding under 482 CRPC. Second point, if your name is not there, there is no locus standi for you. So therefore, you cannot file any petition under section 482 CRPC. But please remember, if you feel that you will be impleaded as an accused, you have got every chance under 438 or 439 CRPC for 438 CRPC for getting anticipatory bail. This is the decision given by the Honorable Supreme Court of India. Very good decision, seems to be simple, but that tricky point I have explained you. So please read the judgment and enrich your legal knowledge. Thank you very much.